Good evening, ladies and gentlemen. It's a pleasure to welcome you this evening to the program on recovery and restoration of artwork taken by the Nazis during World War II. My name is Randy Sue Pollack, and I'm president of the Northern District of California chapter of the Federal Bar Association. Tonight's program is being co-sponsored by the Northern District Historical Society and the Jewish Bar Association of San Francisco. Before we begin, I'd like to take a moment to welcome those of you who are members of the Federal Bar Association and members of the Northern District of Historical Society, and I'd like to encourage those of you who are not members to please join. The Federal Bar Association was started in 1920 and serves to strengthen the federal legal system by providing assistance to the federal practitioner, both private and public, to the federal judiciary, and to the public that they serve. The Northern District Historical Society was started in 1977 and serves to promote and preserve the rich judicial history that is part of our Northern District of California. I'd like to give you a preview of some programs that both of our organizations are going to be holding in the coming months. February 13th, we have a Meet the Magistrates program in San Jose in federal court. February 28th, the Northern District Historical Society, along with the Ninth Circuit Historical Society and the Federal Bar, are going to be presenting a program on anti-Asian hate, which will be held down at UC School of Law. Then on March 26th, we will have a program on the multi-district litigation here in the courthouse that will be open to all Federal Bar members. On April 11th, we're going to have a special program on navigating the Federal Bureau of Prisons, which will also be here. For those of you who are not yet members, I encourage you to join both of our organizations. Outside, there are QR links to help you join both of them. I'll now turn the program over to Dan Bergeson. Dan is a member of the Northern District Historical Society Board of Directors and will be introducing the panelists today. Thank you.
Thank you, Randy Sue. First of all, welcome. Thank you for coming here and braving the weather this afternoon. It was a bit wet here in the Bay Area. And thank you for those online viewing this program, because you're going to be in for a treat. Before we get started, I'd like to start our two sponsors, Christie's and the Barco Law Firm, for their generous support in putting this on. And before I begin to introduce our panelists here, I would like to say a few words about the program. The systematic disposition of Jewish people and the transfer of their homes, businesses, artworks, financial assets, music, instruments, books, and even home furnishings to the Third Reich was an integral component of the Holocaust. In every country controlled by Nazis, Jews were stripped of their assets through a wide array of mechanisms, including Nazi looting organizations specifically created for the purpose to determine which public and private collections were most valuable. By some estimates, the Nazis stole over 650,000 works of art, an estimated 20% of the artwork in Europe from 1933 to 1945. Some of the stolen pieces were created by some of the world's most heralded artists, including Van Gogh, Picasso, and Chagall. Some were earmarked for Hitler's never-realized Führer Museum. Some went to other high-ranking officials, such as Erwin Göring, and others were traded to fund Nazi activities. Efforts to recover these artifacts began in 1944 with the formation of the Art Looting Investigation Unit of U.S. intelligence and other organizations in countries where looting occurred. While some artwork was recovered early on by the groups, such as the Monuments, Fine Arts, and Archives section of the Allies, aka the Monuments Men, you may have recalled the movie with George Clooney and Matt Damon, many pieces remain unaccounted for decades. As we'll hear from our distinguished panel, the often complex efforts to restore these works to the rightful owners and heirs continue to this day, and involves governments, museums, art houses, galleries, individual collectors, academics, and Jewish organizations. Now, to our panel. First, the Honorable Simon Frankel. Judge Frankel is a judge of the Superior Court of California in San Francisco. Prior to joining the bench in March of 2023, Judge Frankel had an extremely successful career in private practice as a partner at Covington & Burling in its San Francisco office. While there, he chaired the intellectual property rights practice group, was the managing partner of the firm, and handled a wide variety of intellectual property matters, including copyright and cultural property disputes. Judge Frankel is a nationally recognized authority in the field of art law and has taught art law at Berkeley Law School, Stanford Law School, the University of San Francisco School of Law, and UC Law San Francisco. Judge Frankel is a graduate of Harvard College, the University of Cambridge, and Yale Law School. Welcome.
Thank you.
Patrick Ryan, next to Judge Frankel. Patrick Ryan is a partner in the Bartco firm here in San Francisco and is one of the most sought-after trial lawyers in the United States, handling cases across the country involving a cross-section of complex commercial litigation, antitrust, trade secrets, intellectual property, and art law. Patrick has consistently been ranked as one of the top lawyers in the state of California. In addition, Patrick was instrumental in the establishment of the Massey Art Restoration Initiative in 2017. This was a historic and unprecedented alliance in which German public institutions, for the first time, agreed to work with the heirs of art looted by the Nazi regime to identify and locate the stolen Massey art collection. Next to Patrick, we have Professor Shurovsky. And Professor Shurovsky is an adjunct professor at the University of San Francisco in its graduate program in museum studies. She has taught art law, copyright, and museum and the law, as well as a graduate internship course in museum studies. Professor Shurovsky has spent most of her law career focused on legal issues related to the arts, technology, and museums, and other nonprofit institutions, and is considered a nationally known expert in this area. Before joining USF, Professor Shurovsky worked in the General Counsel's Office of the Museum of Modern Art in New York, and previously was a partner in a major San Francisco law firm specializing in intellectual property. She is a Yale Law graduate, has a BA in Art History from Brown University, and a Master's of Art from San Francisco State. And finally, Richard Aronowitz. Richard is the global head of restitution for Christie's and has been since March 2022. He's widely considered one of the foremost experts in the area of restitution. Richard was previously at Sotheby's, where he led the restitution department in Europe from 26 to 2021, and he was responsible for building relationships with restitution lawyers, researchers, families, and heirs throughout the world. Richard was also previously the head of the Ben-Uri Gallery in London. In addition to his substantial expertise in restitution of stolen art, he's a published writer of several novels and a collection of poetry. He's a graduate of Oxford University and the University of London. Welcome, everyone, for being here. Now, let's start the panel discussion with Patrick. Patrick, tell us about your work in this area, and in particular, the Massey Art Collection.
Well, first of all, I'm not instrumental in anything. The leader of our firm, John Bartco, and his son Eric are the ones who did the lion's share of all the work on this project. My work has been de minimis. I'm here to tell you about it, and it's exciting. In 2012, our firm was asked to help the heirs of Rudolf Massey recover some of the thousands of pieces of art and other artifacts that were stolen by the Nazis from them. What I'd like to do is tell you a little bit about the Massey family. This is Rudolf Massey. Rudolf Massey came to Germany in the 1860s. He worked at a shop, he started advertising business, and he built one of the largest publishing empires in all of Europe. By the 1920s, it was 130 publications, newspapers, journals. He revolutionized, he was the first to conceive of the fact that you could go into a newspaper in London and place an ad, and you could run it in any of his publications anywhere in Europe. He revolutionized that. He built a massive fortune, but his passion was art and antiquities and homes. He built beautiful homes in Europe, especially in Germany, and he collected art zealously. I'm going to skip over some of these slides because I have too many, and other people are going to deal with the law. This is Rudolf and his wife, Emil. This is one of their homes outside of Berlin. These are just glimpses of some of the art that he and his wife collected. And what's really important that you're going to find out is that they built a beautiful estate in Berlin that, flash forward to the 30s, would be just across the street from Adolf Hitler's office at the Chancellery, which was not fortunate for them. This is inside that home, thousands of pieces of art. Now, what Rudolf Mossy did was he wanted to make that home a center of culture and art in Germany. People from all over the world would attend exhibitions, gatherings, intellectual debates at that home in Berlin, where this art was primarily housed. One of the things that Rudolf Mossy and his publications did was they engaged in vigorous investigative journalism, and they exposed a lot of the things that Hitler and his cronies were doing, and they wrote about them in their newspapers. So the Mossy publications became a central target of Adolf Hitler. He mentioned them in numerous leaflets and publications, that they were part of the Jewish scourge that had to be eliminated. So before the Nuremberg laws came into place, which was in 1935, which basically quasi-legalized taking things from Jewish people in Germany, he couldn't wait for that. He couldn't wait. So in 1933, he sent, it was 6 months after he became chancellor, he sent one of his officers, Wilhelm Orst, to that house in Berlin. Rudolf Mossy had died. He had no biological heirs. He had one adopted daughter, Felicia, and her husband had taken the Mossy name, and they had 3 children, and they lived in that home in Berlin. The Nazi officer went into that house, and he placed a pistol on one side of the table, their passports on the other, and a piece of paper, and gave them an ultimatum. Sign over everything that you own: homes, cars, animals, art, money, to the government, and leave, or I'm going to shoot you. They signed the paper, and they left, except George, the little boy, was away at boarding school. And the story is from his memoir, and he's a professor in the United States at a university. He made it out of the country by 8 minutes before they closed. But he made it. So they were the lucky ones. But what happened to the art? Let me see. This is actually not Wilhelm Orst. It's a picture that I found of another Nazi officer. But these are Felicia's children. And they are the heirs for whom we fight. We've actually restituted now 35 pieces. It's not 34, but what happened to the art? So what the Nazis did was they created a trust for the Mosseys, and they put it through bankruptcy. So no one would know that this was looted art. And they held an auction where they auctioned off thousands of the Mossy art pieces. Some of the buyers were actually Jewish because they had no idea that the artwork had been looted. And it's scattered to the winds, this art. This is the cover that we were able to recover, and this opened up a lot of doors because before that it was difficult to prove what was in the auction collection, what had been looted wasn't. So having the auction records was a huge piece of the puzzle that we were able to acquire. This is the first piece that we were able to restitute. And what this did was it opened a lot of doors, because the museum that had this piece did not want a public auction. They wanted to keep it in their museum. And the heirs wanted the money. So a deal was struck. If they would pay the heirs the market price for the piece, there wouldn't be a public auction. And in exchange, they opened doors to the family. They helped us meet the Prussian Heritage Foundation and start talking to the German government. And this is a very important approach to why we've been successful at restituting so much of this art, is we took an approach that was cooperative, not confrontational, and not shaming, okay? We said, we want to be your partner. And coincidentally, after we were engaged in 2012, there was a huge expose in Germany about looted art. So there was a real need from the German government to do something about looted art. So we were able to capitalize on that. And what ended up happening, it was quite fortuitous, the Prussian Heritage Foundation agreed to create a grant to assist us in identifying and locating the Mossy art that had been looted. So the Prussian Heritage Foundation, which is very influential across most of the museums in Europe, became literally our financial partner in finding this art. And that was a huge turning point. And that is a difference that is really critical to why I think we've been successful. This is another example of one of the pieces that's been restituted. I'm just going to click through them very quickly. This piece on the left has been restituted. The one on the right is an example of one that we're working on right now. It's actually in the mayor's office of a city in Berlin. And this is a good example of people who are in official positions in Germany. They don't want to admit that their predecessors did something wrong. So they doggedly resist agreeing that they have a piece that was looted. And so we're working through those issues, establishing that this actually is a piece that was looted from the Mossy family. As you can see, it's extraordinary. And these two pieces were actually auctioned for us by Christie's, I believe, who's going to talk. This piece was seized a different way. This was in an upstate New York museum. And the Department of Justice and the FBI actually were able to acquire this piece using federal law because it was in the United States. And what you're going to hear from the other panelists is one of the reasons we have to use cooperation is that the laws in Europe aren't as favorable as they are in the United States, and only the museums, not the private hands, have an obligation to restitute. Private collectors don't. And I'm going to give you an example of a piece that we know is in private hands that we haven't been able to get. So this is the Mossy's home in Berlin, the one I was telling you about, that was across from Chancellor Hitler's office. So if you look at the picture on the left, there's a white object. That's actually a sculpture. It's a lion that was in the Mossy collection that was put there by the Nazis when they converted the home into a law school after they seized it from the Mossys. The picture on the right is a fountain that used to be there before the Nazis replaced it. I guess they didn't think it was masculine enough. This piece has a very interesting history. There was a note in the auction logs that it was sold for peanuts to a banker that had relationship with the Nazi government. And finding that evidence was key That piece is now at a hotel, a private hotel. And the sculptor of that piece is on the right. And we were trying to convince that private owner to restitute that piece. And he's been recalcitrant and hasn't. The Smithsonian Magazine wrote a whole piece on this. Fortunately, there's a new owner, so we're going to take another crack at that. But it's a lot of detecting. It's exciting. And it's very historical. And it's just one piece of the lives that have been torn apart by the Nazis. And I think it's the first example of Nazi looting artwork because it happened almost immediately after Hitler took power, because he was laser focused on this family. He wanted to destroy this family, and he could see them from his office. So.
Patrick, thank you so much for that. I've quite a few questions, but I'd first like to turn it over to Judge Frankel to talk about his efforts in the recovery, how he got started, any issues that he encountered through his experience. So, Judge Frankel.
Thank you. As you'll see, most of my work has actually been on the other side, representing good faith possessors of art that changed hands in the Holocaust. I started out doing a smattering of art-related issues in the mid-1990s when I was an associate at a law firm here, and I was also teaching a class on, can we get, I don't need them yet, but can we get my slides for a moment? Thank you. And I was also teaching a law school class with my father at the time, and I'm still teaching a different version of it, but very similar at Stanford now with a friend. And so over time, I started to do some art-related work in my practice, and when I moved to another firm in 2006, I was very lucky. The Museum of Fine Arts Boston was already, the firm was already doing some cultural property advisory work for the museum, and they ended up having a couple of litigations of some significance that I led. So as I just mentioned, most of my work relevant to today's panel was on behalf of museums, or in a couple of instances, other possessors of artworks that changed hands under the Nazis, or antiquities that had been imported into the US at some point, which we won't dwell on the antiquities part beyond the scope here. But I was very lucky to work with the Museum of Fine Arts Boston because perhaps by happenstance, it had was ahead of a lot of its peers. It had it was the first major U.S. museum to hire a full-time provenance curator in 2000, and even before that, starting in 1998, it had begun a systematic review of the provenance of its collections. 1998 is a date of some significance here, as you'll hear. And the museum was trying to identify objects that may have been sold or traded during the Nazi era to understand if there were disconcerting gaps in the provenance, and so it has been over the years, a real leader in analyzing collections and engaging with claimants, and in sometimes even bringing pieces to the attention of potential claimants who didn't even know that their families might have owned it decades earlier. But when that's where the evidence is led, that's what the museum's done. So I wanted to say a few words about the litigation we're seeing, not just the Mossy litigation that Patrick talked about, but other litigations generally. Say a few words about how museums in the United States have tended to respond to claims for works in their collections that appear to have changed hands under the Nazis. And then I'm going to talk about one particular case I handled for the Museum of Fine Arts in Boston, just because it's a fun story, and also because it gives you some sense of the kind of historical digging that Patrick mentioned that is so important in these cases. I think Professor Swarovski will say more on this, but I wanted to say a few things about why are we talking now in 2024 about what happened between 1933 and 1945? Because I think a lot of people come to this and think, hasn't this been figured out before? And why now? And I think there's a whole lot of reasons, and I'm only going to mention a few of them. I'm sure I'll miss some, and others will mention them. One is there was a real reticence. Well, for one thing, many people died, and they were not around to make claims after the war. Those who survived, many had a tremendous, obviously, putting aside all the other things they suffered, they had, to put it politely, a reticence to going back to those issues, to pursuing claims. There was a process that was the result of the Monuments Men's work, which was that works that Monument Men collected, that they recovered. There was a key decision made by the United States, which was they were not going to be turned over, they weren't going to make an effort to find the owners of the works. They were going to turn them over to the countries where it was believed the works had been before the war, and leave it to those countries to figure out how to find the right people for them. And those systems didn't always work well, and people weren't always aware of them. And as I said, people were reluctant to pursue their claims. Many wanted to put the past behind them, given that they'd survived. I think a later generation, or after the passage of time, some members of the original generation became more interested in finding out what their families had owned and making efforts to reclaim it. And then there were some key developments. One was after the fall of the Berlin Wall, there was a tremendous increase in the amount of information available about works. The Nazis were fastidious record keepers, and they required a lot of record keeping of Jews. So for example, in occupied countries, as a first step, Jews had to fill out very detailed property declarations, in many instances before they were trained off to concentration camps, and those were all kept, and many have survived, and they provide detailed information on what families had owned in 1936, 38, 39. Then there was a real recognition in the United States, which I think sort of spread more widely in the 1990s, but under the Clinton administration, led in part by Stuart Eisenstadt, of the need to address restitution of assets to Holocaust survivors while they were still alive. And that went beyond artworks, but artworks was an important part of it, and his efforts led to the Washington Principles of 1998, which I think Professor Swarovski will talk about briefly, so I won't. But these principles, while not enforceable, reflected a sense that property taken from families during the Nazi period should be returned. And then you, of course, had the explosion of prices for art in the 1980s and 90s, which made the stakes much higher. And then in the 2000s and 2010s, the emergence of a sort of specialized plaintiffs bar of lawyers who specialized in these cases and took them on, including on contingency. And then there was the development of some funding entities, Mondex is one, that would actually fund these cases, essentially taking them on contingency for themselves. And I think you've also seen a meaningful attitude that Patrick alluded to in the attitudes of European museums, which, unlike American museums, are almost all state-owned. And so they have, if you went back 25 years, I think there were a lot of works that had belonged to Jews in the 30s that were in state-owned museums in Europe. And the attitudes of most of those museums and their governments was, what's the problem, to speak colloquially. And now I think it's really shifted. I'm not saying it's perfect, but Patrick alluded to dealing with museums that are taking a very different approach and working through factual issues to understand, was this actually taken? Okay, and then we have to do something about it. What that is may depend, but and then one other development that's relevant to the United States is there was a sense, which I'll come back to, that some of these cases in the United States in litigation that were being decided against claimants based on statutes of limitations. Not surprising, since many of these claims were brought 60, 70 years after the events at issue had occurred. This led to a push to address that, which culminated, there were efforts at the state level, particularly in California, to change the statute of limitations for claims to Nazi art, and they were generally struck down as interfering with the foreign affairs power of the United States. Those in favor of this, including the plaintiffs' bar, went to Congress, and Congress in 2016 enacted the Holocaust Expropriated Art Recovery Act, which essentially it preempted state statutes of limitations and enacted a 6-year statute of limitations. But more significantly to me, it provided that the time for bringing a claim began to run from actual discovery of the right to the work and the whereabouts of the work. Previously, most states, not all, had a 3 usually rule and a constructive discovery. So for you lawyers, you know that means when a claimant knew or could have known reasonably. And so as you'll hear in the case I'll talk about, courts under that standard had found that many claimants were on notice of the right of possession but had waited too long. As of 2016 and until December 31st, 2026, you have the 6-year statute under the so-called HERE Act from actual discovery, and so there's been many more claims in this period. A lot of works that came out of Europe that did leave Europe, some restituted to source countries, some that left Europe in 1938, 39, 40, 41, ended up in the United States, and many of those ended up in U.S. museums. So there have been a number of these claims that have been against U.S. museums, and I want to say just a few words about the, to me, sort of distinctive position of U.S. museums with respect to these kind of claims. I wrote a long law review article about this about 10 years ago that surveyed all of the cases against museums at that time, but I'm going to try to spare you having to look up the link that you were provided and read it by telling you what it said in a few minutes. And I think that's what I said there has generally been true since. Museums, as they're generally organized in the U.S., as I said, most of them are private. They're mostly charitable trusts or nonprofit corporations. And to me, they have conflicting duties. They have a duty to safeguard their collections, to take reasonable steps to preserve trust properties, but they also have museum guidelines from voluntary associations, which Karen will talk about, I think, that impose duties on them to research objects in their collections that may have been looted and, if appropriate, to return them. So they're a museum faced with a restitution claim, or even just from its own research, an object in its collection that has a gap in its provenance from the Holocaust period. On the one hand, it can't simply restitute the work to the claimant without convincing itself that this is a meritorious claim, or at least one that may be meritorious, but there's missing evidence perhaps. But it does mean museums should reasonably investigate a claim, and if they determine they're meritorious, turn over the work. But at the same time, I think museums have a duty, if they decide that a claim may not be meritorious, and there are some that are less meritorious, to take reasonable steps to hold on to the work as part of their collection and to do it efficiently, and that may also include invocation of statutes and limitations where appropriate. And as I said, I think if you step back, you find that that's been, by and large, what American museums have done. There have been a lot of cases where museums have resolved claims, very much similar to how Patrick said, by returning works. They have reached negotiated resolutions, such as I know of instances, including with the MFA, where they agreed that the claimant would give half of the work to the museum, donate it, and the museum would pay the claimant for the other half, and then there would be obviously some credit going forward. So that was sort of a way to resolve it, to resolve those claims. And there's been a whole range of resolutions, but there are far, far more cases in the United States where museums have reached an agreement with claimants than cases where they've actually litigated it. Now I'm going to just tell you a little about a case that I handled for the museum that I think was part of this pattern, but also gives you a sense of the intricate facts of these cases and how much the cases depend on what information can be located about the provenance, the history of particular pieces. So this is a marvelous painting that's in the collection of the Museum of Fine Arts in Boston. It was painted by Oskar Kokoschka around 1913. He was a well-known Austrian expressionist and an intense guy. In 1912 to 14, he had a passionate affair with Alma Mahler. After her husband Gustav Mahler, the composer, had died, and after she had an affair with Walter Gropius, the architect, whom she later married, Alma Mahler was sort of the it girl of early 20th century Vienna. And as it says here, she rejected Kokoschka after several years, explaining she was, quote, afraid of being too overcome with passion. So, and this is a self-portrait of that Kokoschka did of himself and Mahler, and I just was going to quote the museum wall text. Kokoschka's haunted expression and the ambiguous poses of the two lovers, who seem both to embrace and to move past each other, reflected a complex and tormented relationship. So he painted it, he sold it to a collector. That collector sold it a year later to Oscar Reichel, who was a Jewish doctor in Vienna and a pretty prominent collector, who actually purchased about 5 different works by Kokoschka around the same several years. And he was buying and selling works many times in the following decades. He consigned this painting to Otto Kallir, a Jewish art dealer in Vienna, in the 20s, but it didn't sell. And he had 2 sons, Raimund and Hans, who were actively involved in his loans and consignments of his art collection, which you'll see is relevant in a moment. Then came the Anschluss when Germany annexed, took over, however you want to phrase it, Austria, and Jews were forced to register their assets. Oscar Reichel filed a property declaration that included this and other works by Kokoschka and other well-known artists. And then by February 1939, Kallir, the dealer, had moved to Paris and opened a gallery there. And in February 1939, Reichel transferred the 5 Kokoschka paintings, including 2 nudes, lovers, to Kallir. I say transferred because when the museum began its research, they weren't sure what had happened. And the work was taken by Kallir to Paris. It was exhibited there, then in New York. And it's important to understand, Kokoschka was not well known in the United States at this time, but Kallir really promoted him and other artists that he had works by, and in essence sort of created a market here for them. But the key question was what had happened in 1939. There was documentation about it in Kallir's gallery, and it had this unusual wording that may have been intended to avoid an issue with the Nazis, but it just said the paintings had been turned over. The currency was given in Swiss francs, not Reichsmarks, and that wouldn't really have made sense for Reichel. As a Jew, he wouldn't have had been able to do that, but he would have had to report the Reichsmarks to the government, and it doesn't appear he did. But what the museum's research turned up was after the war, Raimund Reichel spent decades in Argentina before he moved back to Vienna in 1982, and he died in 1997. And in the 1980s, he corresponded with several art historians about his father's collection. The art historians had tracked him down, and they were interested in what had happened to the Reichel collection. And as it turned out, the museum's provenance researcher was able to find these art historians and find these letters from the 1980s. And in one of them, Raimund Reichel explained that what happened is that Kallir, the dealer, had paid the 2 sons who had been able to get out of Germany, get out of Austria, and had paid them, one of them, money for both of them in New York. It doesn't look like a lot of money, but at the time it was probably in the market for what these paintings were worth. And it was clear that Raimund had kept in touch with Kallir after the war. And then what was so interesting is after the war, this Raimund, who was the son who lived for a long time, had submitted numerous applications on behalf of himself and his brother for restitution from Austria for artworks that had been taken from the family. And he sought restitution for a large number of works by the artist Ramaco that had been owned, and he specified it by catalog raisonné numbers, but they never sought to make a claim for the works by Kokoschka in this or any other restitution application. And it appeared to reflect that they had been relatively knowledgeable about their father's collection, but hadn't sought to recover these works because they knew of this transaction whereby Hans, the brother, had been paid by Otto Kallir in New York, but they did seek to recover and did recover many works after the war by other artists. So when this claim, what happened is Raimund died in 1997, and in 2007, his heir, who was not part of the family, not related, she was a nurse he had known in Vienna, she brought she came to the museum and asserted a claim. It was months of negotiation and research by the museum. They couldn't resolve it. The museum filed a declaratory judgment action to quiet title. The Austrian nurse Claudia Seeger-Tomschitz counterclaimed for seeking possession, and the museum sought summary judgment early based on the statute of limitations, based both on the passage of time when the sons would have known about the existence of the work, which was in the catalog raisonné for Kokoschka and others. For those of you who may not know, the catalog raisonné is an exhaustive listing of all the known works by a particular artist. In any event, and also the nurse herself had waited for a long period after she knew facts relevant to this, and the district court found the claim was time barred on both those bases. The First Circuit affirmed just on the second basis that the heir had waited too long after she knew. The case would have been very different if it were litigated 10 years later with the HERE Act. Then you would have gotten to the merits, and the real question would have had to be decided of whether this transaction was a legitimate transaction, which it appeared to be, but I know some people would question it. And that's all I had to say.
Thank you, Judge. So, Richard, I'd like to turn it over to you and ask you why restitution is important and how the great auction houses have dealt with recovery and, in essence, acted as a filter in this area. So,
delighted to speak on those topics. Just get my slides up. So, as you've heard, my name is Richard Aronowitz. I'm relatively new to Christie's, having joined the firm in only March 2022, but I spent best part of 24 years at the other house, 15 of those in restitution. So really in my career, I've gone from being a fine art specialist looking at the fronts of paintings to now spending my life looking at mostly, admittedly, scans of the backs for evidence of loss and looting, stamps, labels, marks, inscriptions. And I have the honor and the distinction, I guess, on this panel to be the only non-lawyer. I'm very much an art historian of at least of sorts. So what I have to tell you is generally a sort of life lesson rather than a legal analysis. I mean, you've heard quite a lot of what I'm intending to say already in different forms. I often use this slide. I don't know if you can see it very clearly, but if you look at the very center of the image, you'll see a lone man standing there. He's a lone GI, so he comes from this country. And I think it speaks volumes because it shows him towered over by crates and stacks of recently recuperated looted art, all brought for eventual onward forwarding to one of the so-called collecting points to a church in Ellingen, Germany. And I think it just gives you a sense of the scale of what the monuments men and women were faced with from 1945 onwards. You've heard a little bit about them. They were a bunch of men and women from the Allied forces. They're active service men and women. They weren't just men, although they tend to be referred to as the monuments men. And they were a unit set up at the end of the war to comb the fabric of what had been Nazi Europe, to check on the built environment, so cathedrals, castles, all those sorts of things, important historical landmarks. But a secondary function was to look for caches of looted art and to retrieve those caches and take them for sorting at the various collecting points they set up. And I tend to say it's a bit like trying to imagine reversing the Big Bang. I mean, although I think we heard the figure earlier of something like 650,000 paintings or fine artworks, that's really just the tip of the iceberg, because of the Nazis pretty much stole as a mechanism of persecution everything that Jewish families owned, if they could, from tableware and cutlery upwards. So you're talking about countless millions of objects that were looted. And although the monuments men and women, of course, focused on fine art, they also encountered many other sorts of forms of objects that were looted and tried again to unite them with their former owners or their successors. And you've also heard that reuniting of object with owner was not done by them, it was done by the country that they deemed the object to have been lost in. So it was up to the local government to do the actual restituting, and that's often where the process broke down for very obvious reasons. Often victim of the loss hadn't survived. And if a descendant had survived, that descendant may be half a world away in Brisbane or Tasmania or Shanghai. So that's where often the great problems came. I always loved pivots of history, and this building, for me, represents one of those. It was Hitler's, we heard of his chancellery in Berlin. Well, this was his Führerbau in Munich, and of course Munich wasn't a bit part player in the mighty Nazi apparatus. It was one of the epicenters. And it went from being Hitler's headquarters in the southern part of Germany pretty much overnight to being the Munich Central Collecting Point, the biggest of the monuments men and women's various centers where they did their work to sort recently recuperated caches of looted art and cultural objects, work out, of course, who they were made by, but more importantly, try to work out with the inventories that you've heard about where these things had been looted in, which country, or where they'd been forcibly sold in. And then their job was, once they'd sorted that out, to try to repatriate the objects to those countries where the loss had occurred. So this became a force for great good, that building, having been a sort of very malign presence in the centre of Munich. This is the monuments men and women going about their work, just like we at Christie's have our wonderful cavernous basements. I'm thinking particularly of King Street in London, where I work, where our pictures and fine art objects are stored. They had a very similar system where the objects were stored also for condition, looking at condition, working out what inventory marks, stamps, labels might have been on the back that would help them dig further into the 1933-45 ownership and transfer of these objects. That was them going about their work. And I must admit, this film is much talked about because it raised the public's awareness of the work of the monuments men and women, which is a wonderful thing to do. I haven't actually yet seen it myself. I did try and watch it once on a flight from London to the US, I think to New York, and I managed 10 minutes. But I found the tone quite light, and it was very much to my mind like the English program Dad's Army, which is probably not very well known over here. So I must admit I switched off, but one day I'll get around to it. But the wonderful thing is that it really did raise awareness, thanks to the star power of Matt Damon and Clooney, etc., to the wonderful job that those men and women did. Their efforts really had come to an end by the early 1950s, and this is where my story really begins, and I know we have very limited time. I properly joined the international art trade, having experimented with it as a furniture porter at Bonham's auction house in London. I properly joined in 1997, and being of Jewish background, and being a sort of scholarly type, I used to sit in the library of the Impressionist and Modern Art department at Sotheby's, looking at old auction catalogues from the 60s, 70s, 80s, and 90s, Bonham's, Phillips, Sotheby's, Christie's, German auction houses, French auction houses. And what struck me most, apart from the wonderful array of objects I was looking at in these printed pages, was the endless Jewish surnames printed in the provenance section of the cataloguing, the ownership history. And I used to think, what on earth happened to those people behind those surnames? And what happened to that object? I'm looking at this Monet or Pissarro or whatever in this printed catalogue from Bonham's or Phillips or Sotheby's or Christie's. And frankly, no one in the international art trade, as far as I could tell, thought much about that question in the 90s when I joined the art trade. And something monumental and seismic happened in 1998, which you've heard about, which was the Washington Conference on Holocaust-era assets in late November, early December 1998. It didn't come out of nowhere. There'd been other claims. There'd been Swiss banking claims. There'd been other forms of looking at the past through the lens of what was lost, not just lives, but what was lost in terms of Jewish ownership of things, whether those things be bank accounts or insurance policies. Other things, which you've also heard about, key historic developments led to the 1998 Washington Conference, such as the fall of the Berlin Wall and the Iron Curtain, the opening up of archives in former Eastern Europe, which had previously been inaccessible to Western researchers. Another key one was, of course, the advent of the internet. So the information wasn't just available in archives, it could be digitized in some form and disseminated. So there was a building sort of momentum the Clinton administration became more and more aware of the unresolved nature of the fate of Jewish-owned art during and after the Third Reich, and they commissioned a man called Ambassador Stuart Eisenstadt that Christie's had the great honor of hosting as a keynote speaker in early October at Christie's New York, talking about these very Washington principles that he drafted. And these are not laws, of course, as you've heard. These are moral, ethical guidelines to which we at Christie's and the Restitution Department work. And I don't know if you can see them on your screens, but number 1 says that art that had been confiscated by the Nazis and not subsequently restituted should be identified. Number 3 says resources and personnel should be made available to facilitate the identification of all art that had been confiscated by the Nazis and not subsequently restituted. So principles number 1 and 3 probably explain to you quite clearly why auction houses like Christie's have a restitution department. And we have the great gift, really, that we're a team now of 11 or 12 people. The vast majority of those are researchers who spend their working lives researching the 1933-45 ownership history, what we call provenance of the art objects, and those can be anything from tapestries to Rembrandts that Christie's would like to sell around the world. So before they enter into a printed catalogue, let alone onto the auction block, our team do quiet research, trying to be as sure as they can be that the objects weren't looted between 1933 or 45 or sold under duress and not recovered after the war. And that's a vast needle in the haystack job. As you can imagine, we have auction rooms all around the world, and we sell, I don't know how many thousands of lots per annum, many of which were made before 1945 and then need to come under our scrutiny. And we're there to try to make sure that nothing that was looted or sold under duress enters the sale without having been discovered and its history resolved. We don't have much time to delve into the sort of minutiae, but you can perhaps imagine the scale. And you may wonder how many things come up in the international art market, or in our case at Christie's, that we discover. I don't know how many lots we look at. We look at probably between 12 and 18,000 a year, something like that. So the scale is vast. We are there, as I said, to try to make sure that we know as much as we can do from the bibliography on the artist and the artwork, through dialogue with our expert department colleagues, often working also with freelance researchers. We try and build as complete a picture as we can about the ownership history between 33 and 45. It's not always possible to piece together a seamless provenance between those years, but we do our best to be as comprehensive as we can. And we do regularly discover works with either gaps that are worrying because of, say, the last known Jewish owner detail ends at 1930, and then there's a gap until, say, 1950, and that leaves a very open question. Or there's a very obvious Jewish name in the provenance between 1933 and 45 that leads to further thought, that leads to an obvious problem. A couple of years ago, before my time, in November 2021, Christie's New York sold this very, very beautiful, I hope you can see it, watercolor and gouache by Van Gogh. A beautiful work for the illustrious Cox collection, a US-based private collection. And as my colleagues were doing their research, they found out that the work had been owned essentially by two important Jewish collectors, one in Berlin and one later on in Paris. The first was a man called Max Meyerowski, who was a Jew in Berlin, who fled Nazi Germany for France to try and get out of Europe. He fled in the late 30s. France, of course, was not occupied by the Nazis until 1940. He sold the work in Paris to an émigré dealer, who then sold it in turn to the very well-known French Jewish collector Alexandrine de Rothschild. And one view of Max Meyerowski's sale of the work, having fled for his life from Nazi Germany, although he sold it in Paris, it could be argued that the reason for his sale was one of duress, because he was fleeing for his own safety from Nazi Germany. So his heir had to be taken into account before we could offer the work for sale. And then much more concretely and clearly, the work that had then been looted from Alexandrine de Rothschild once France was invaded in 1940 by a body known as the Einsatzstab Reichsleiter Rosenberg, what we call the ERR, so the Nazi looting agency in occupied France and Belgium particularly. And it was recorded as an item that was confiscated by them clearly in the documents pertaining to the ERR's action. So we had to take into account two different potential claimants, the Myrovsky heir and the Alexandrine de Rothschild heirs. And we worked, or my team worked with the lawyers representing both of those individuals and groups. And in the end, a tripartite settlement was reached. So the object was still sold at Christie's, New York, but the sale was between the Cox family, who were fully cooperative in the process, the Myrovsky heir and the de Rothschild heirs. So it was an unusual tripartite arrangement. And this is the theory of restitution reified in the art market context, which is usually, but not always, a solution that involves a financial settlement. Not everything. That Van Gogh sold for something north of $19 million. I don't have the exact figure in my head, but we don't differentiate in our research. So whether we're looking into the ownership history between 33 and 45 of a Rembrandt or Titian, or of something like this, which is a fairly humble late medieval casket, the work involved is equally arduous and complex and time-consuming. This was, as you can see, a wooden carved casket, been owned by another branch of the Rothschild family, in this case the Goldschmidt-Rothschilds in Germany. And as you heard earlier, the Nazis were both wonderful inventorizers, but also wonderful inventors of laws to allow themselves to do the looting and the duress sales and the confiscation, and also wonderful inventors of punitive taxes. In this case, they invented a tax liability for Rudolf von Goldschmidt-Rothschild. Because he didn't have the financial means to pay these invented taxes, he had to hand over instead his collection. This humble casket was one of the objects he had to hand over among innumerable others, and it emerged at Christie's. And again, my team, long before I was there, discovered the invented tax liability and the fact he'd handed over this casket to settle that part of the tax. And they, again, worked with the Goldschmidt-Rothschild heirs through their lawyer in Germany and with the current owner, our then consignor. And I think a rather nice outcome was in that case, perhaps given the very humble nature of this object, both sides agreed to give their share of the sale proceeds, and it's not always 50-50. It very much varies on the dialogue and I suppose one could call the drama of the nature of the loss. They decided to give both of their shares to charity, which was perhaps an unusual outcome, but I think a rather lovely one to learn about. I'm going to conclude on this slide, because or maybe one more, but this is another object. It was a wonderful Monet, as you can see, owned by a Jewish collector called Richard Semmel from Berlin, and his wife, another Jewish collector like Myrovsky from Berlin. He fled very early from Berlin, in his case in 1933 with his wife. He wasn't only a Jew, he was also an ardent communist and a pamphleteer. So he tried to spread the communist word by leafleting, doorstepping households throughout Berlin. So he was, like with the Mossers, he was a very, very early target of Nazi opprobrium. And he fled to Holland and then onwards to North America. He auctioned off his Impressionist and Modern Art collection and his old master paintings collection in two separate sales at Frederick Muller Auction House in Amsterdam. But the key thing here is it was in 1933. But again, bodies such as the Dutch State Restitution Commission and other museums around the world have usually decided that the objects in those two auctions in the summer of 1933 and in November of 1933 should be restituted to the Semmel heirs, because although the auctions happened 7 years before Holland was invaded by the Nazis, the causality has to be taken into account. Richard Semmel and his wife had fled Berlin for Amsterdam before they left for the New World, and therefore the sales of those two collections of artworks should be seen as happening because of duress. So almost invariably, Zemel property is restituted. In this case, it was consigned to Christie's for May 2022 sale in New York, already with a settlement in place that had been done before the painting came to us, essentially. I'll conclude. We're probably a bit out of time, because this dog is very popular among certain people in our audience, and it's one of my favorite stories. It just shows you sometimes, to be frank, how complex and nuanced and, in some cases, tenuous claims can be. This very delightful little dog called Bob was painted by Manet, as you can see, and the Jewish element of the provenance is that it was owned by a very esteemed, famous Berlin collector called Estella Katzenellenbogen. She has the most wonderful surname because Katzenellenbogen means cat's elbow. So her name was Estella Katzenellenbogen. She was married for a long time to a man called Ludwig. She then left him and fled Nazi Germany again from Berlin, another one from Berlin. So we've had Meyerowski, we've had Zemel, and now Estella Katzenellenbogen. She fled to here, she fled to California, in her case Santa Monica. And the key thing is that she brought this painting, among others, with her. She sold it to a New York dealer, you can see Carol Carstairs, and my team could only show that she'd had it at least until March 1945 before selling it, having arrived in California from Berlin in the late 30s. They couldn't, however, show that she'd held on to the painting and had it until the end of hostilities with Germany in May 45. So the lawyer acting for the heirs of Estella Katzenellenbogen argued, because she had most likely sold the painting during wartime, that sale was involuntary. It was essentially a duress sale, because she needed the funds from the sale of that painting to survive on as a Jewish refugee from Nazism here in California. So again, that painting was sold with a settlement in place. And that was perhaps the most nuanced, sort of attenuated end of the settlement spectrum because of the nature of the claim, the work having been sold in New York in 1945. And we better stop there and pass to you.
Thank you, Richard. And that's a nice segue to Professor with regard to, case law and developments as it relates to forced sales and sales under duress, both here in the United States and in Europe.
So I have the distinct pleasure of not only practicing in the field when I was practicing, but also teaching at both the University of San Francisco Law School, where I teach courses that include art law, as well as teaching in the graduate program of museum studies, which is a wonderful program at University of San Francisco as well. So I teach to both lawyers and to individuals who are going into the art world and the museum world in all of its different forms. And today I'm going to try and knit those worlds together, give you a little bit of an overview of not only the law, but a little bit beyond the law, so that we can put all these wonderful stories and histories in context, and also give you an idea of what has been happening most recently, so that as you keep your eye on the newspaper or the internet, you will be able to see in real time the development of different cases. So that's what I'm aiming to do for you this afternoon. First of all, we've heard a lot about wonderful principles and the effort it took internationally in articulating them. We've been lucky enough, Richard did a little bit of my job for me, so thank you, Richard, in talking about the Washington principles. Judge Frankel also mentioned that, talking about a just and fair solution to these cases where artwork was looted, stolen during World War II and in the lead up to it. There is also a declaration, another international declaration called, from Terezin. It was called the Terezin Declaration, also worked on in large part and signed off on by the United States. And that declaration effectively took the idea of this let's not worry. I'm going to speak in English to all of you. Let's not worry too much about all the different technicalities of the law. We are aiming for this just and fair resolution. What it did was it also extended the concept of just and fair resolution to works that may have been sold under duress. So that was a further extension in 2009. At the same time, in the United States, we had developments where the museums themselves, through their, essentially the trade organizations, and the two major ones are the American Association of Museum Directors, which by and large represents a little bit larger museums, and the American, now called the American Alliance of Museums, both came out with guidelines that were aimed at what are best practices, if I can translate it that way, for museums when faced with these types of issues. Wonderful, wonderful statements, aspirations, and none legally enforceable. That's the most important thing to keep in mind. So, I turn your attention to competing concerns, and Judge Frankel was exactly right in talking about legal duties, but I want to tell you what is competing in this area. Number one, we do have the ethical standards, by and large articulated by different groups. Okay? Then we have the moral responsibility, which I certainly can't decide anyone's moral responsibility, but clearly there's a different sense. It differs by country, different by entity. Individuals may feel less of a moral responsibility than perhaps an instrumentality of the state, and that is determined, and as you can see, weighs very heavily on the resolution of these issues. In the case that Patrick was talking about, with the intensity not only of the focus but also of the feeling by the Germans, and the need to step up for a number of different reasons. And then of course we have what Judge Frankel talked about, which is that museums are bound by legal duties that are both, actually they're ethical and legal in nature, and that can also determine how a museum must proceed, and certainly lawyers for the museum. So there's constantly balancing concerns that go into all of this. Just a very, I like to call it the 35,000-foot view of stolen property in the United States, because we don't need to go deep into the details, and I don't want to take that time. But what you should know is that the significant difference between the United States and other countries is that in the United States, once stolen, always stolen. In other countries, particularly in Europe, there is the possibility of being what we call an innocent purchaser or a good faith purchaser, and therefore there is not the same type of liability. The work can stay with the good faith purchaser. If you just think in terms of common sense, it makes sense. Someone may not have known. We heard from Richard all the different ways that things can go from different owners, and so there's a different decision that's made. But in the United States, by and large, this is general, once stolen, always stolen. That also has been included, and I like to use pictures just to make my points because I don't know what kind of learners you are. So the visual learners, take a look at the photos, right? You see the thief with the bag of loot, but right underneath it is someone holding a painting facing a bayonet behind them with people holding cash in front of them. That represents forced sales or sales under duress. In certain cases, and I can't emphasize this enough, and Judge Frankel talked about it, these are case specific. Every single one of the cases that you've heard about go down to the details. That's very, very important because it can decide how the case ultimately turns out. But in certain cases, when you are selling for your life or its equivalent, there is a recognition by U.S. courts that that is equivalent to theft. Once you get it equivalent to theft, remember the rule. good faith purchaser is not going to be able to hold on to that artwork. So the questions we're left with is when we talk about art and sales, we get into some details like, is the art that is stolen, number one, is that paying for punitive taxes, which we heard a case of? You absolutely have to pay this tax, you have no money, you only have art. Guess what you're going to decide to do? Or is it to pay living expenses for someone who was under the Nazi rule during that time? What about traded for visas or otherwise used to fund escapes? How are we going to treat that? Is that considered for sale, sold under duress? And then we have the cases of things that were sent out of the country that basically helped fund either escape or otherwise. You're restarting your world in another country. You're using the proceeds from art that may have left in order to do so. So those are specific cases. I can't give you the answers to each one, but that is what courts look to in order to figure out, is this a forced sale, is this a sale under duress? The key points and challenges, I have to admit, I loved seeing the Monuments Men, and I saw that in Richard's materials. So I decided to throw in another movie that you might enjoy, which is The Woman in Gold. I highly recommend it because, in my mind, it gets to the truth of law, and sometimes Hollywood movies don't do that. The crucial question in this case, which was a portrait of Bloch-Bauer, was whether or not jurisdiction could be established in this country. And the reason that was the key point of the case is that if this particular Austrian heir was able to come into the United States, you now know the legal scheme was different. Once stolen, always stolen. So that was the key issue. And in fact, jurisdiction was established. No surprise, as soon as that decision was reached, the case quickly moved on to a settlement. Remember that goodwill is wonderful. Law is what we have to hold people to account. If law is not robust enough, it cannot get people to the table. So we do need some good cases in order to light a fire under others who may, moral or ethically or otherwise, may also need a little bit of a push to do the right thing, at least in this country. Okay? That said, very specific. The other thing that Judge Frankel told you about was the extended statute of limitations. So keep in mind there are the merits of the case, and then there are certain things put in place that can easily dispose of cases early. Usually when you're delving into the facts of the case goes on for a while. You have the discovery phase, you're trying to unearth all of the different facts. The HERE Act was designed to change this rule of discovery to make it clear that it was actual discovery and to give claimants a little bit more time to bring their cases so that certain procedural hurdles would not stand in the way. That being said, there are a number of challenges in these cases. The first one is that the United States doesn't really like to busy itself with the actions of other foreign governments for a very simple reason, which is we don't want it coming back at us. We don't want to be hauled into a German court as a country for actions that may have been taken by our particular federal government or its instrumentality. And so that has proven a burden and a limitation. It is hard. It's not that easy to establish jurisdiction. And as we heard from Patrick, the jurisdiction is key not only for the assistance of U.S. authorities, but for bringing the cases themselves. So that's key. We have the problem of the Foreign Sovereign Immunities Act as it has been interpreted, particularly with the current Supreme Court. We also have another defense, and I wonder in both Judge and Professor Frankel's case, if the HERE Act was in place, and we can certainly talk about this ad nauseum, I'm sure, would there have been a good, equitable argument that could have been made as to what we lawyers call latches, and what I say in English is an unreasonable delay with prejudice. It's basically a way of saying, did you wait too long? And did that delay prejudice the defendant? So it's equitable in nature. It tries to even the score. There are some changes. Again, happy to discuss all the legal details, but we're not at that level. So that can also be a potential bar that can come into play. And then finally, the issue of proving duress. We've all been throwing this language. It's duress. It might be duress. It's not that easy. In certain cases, the case that Patrick gave us, the gun is on the table. The passports are on the table. There is clearly a direct threat. I don't think any one of us would have difficulty in saying, yep, that counts. But in many other cases, it's not as clear. And that's what we try and struggle with. Now, given you that background, what's been going on lately in the courts? Very quickly, you can all look through these slides. Happy to make them available. The Zuckerman case is very important because it looked at the HERE Act and that effect in the context of a case that allegedly involved duress. You can see a little bit of the background here. The lower court did find that there was not duress. So this was a case that was brought against the Met, very prominent painting. But what happened was the case went up on appeal. And so on appeal, it was upheld on a different basis. And the basis was the basis of latches, the equitable defense. What was a little bit unusual and notable for those of us following these kinds of cases was, number one, there was an open question. Did the broad principle saying there should be just and fair resolution and the HERE Act, did that somehow change the ability of the defense to raise questions? They lost statute of limitations. The HERE Act said you have more time to bring the case. But there was an equitable defense that was still available to the Met that they succeeded on, and that was the defense of latches. So that was a very notable case in telling us that the increase in time and the statute of limitations did not necessarily remove the possibility of making these equitable defenses. And that was the basis on which the court, when we cite it, it is not cited for the issue of duress. It is cited for the idea that latches was found. So that was one of the cases. That was in 2019. This was a case that went up to the Supreme Court, very well-known case of Jewish art dealers who invested in a trove of medieval relics, very important to Germany. This went up and down. There were a number of different, you can follow this. These court cases take a long time. They cost a lot of money. But in essence, the takeaway from this was that the Supreme Court, there was a ruling at the circuit court level that we thought was going to be very interesting. The Supreme Court interpreted the Foreign Sovereign Immunities Act in a way that said, nope, this is covered. We are not going, this is not appropriate to get involved. It was sent back down to the lower court, some very interesting arguments about whether Jews, given the laws, the Nuremberg laws and other laws, were essentially excommunicated, if you would, and did that make them not citizens of Germany? There was an issue of whether or not that was raised at the appropriate time, and it did not proceed on that basis. So that's where that case currently is. We have another case which involves Max Emden, which is a very, very interesting case. This involved a mix-up of 3 works. There were, again, this is taxes that were imposed on property that was in Germany, and to help his family members flee, Emden ended up selling 3 works by Bellato, and some of the works, as actually everyone has told us, the monuments men had an assumption that unfortunately was an incorrect assumption, which is if we give it back to the countries, they'll figure it out. 2 were sent to Germany, after a long period, eventually restituted. The other one was mistakenly sent back. Unfortunately, in this case, which we only see right now the decision out of the lower court, the trial court level, this involved the MFA of Houston, the lower court looked at this and said, protected under the act of state. And so the decision was that it could stay with the person that it had been sent back to. So that is that current case. You can see we're kind of inching up to more recent cases. There are some claims you need to know about. If you follow this area, you don't always see, there is not always as much transparency for obvious reasons, because so many of these works are worth so much money. And so we need to be mindful. There's a lot of money, there are a lot of feelings going on. As a layperson trying to pay attention to this, you don't always see what's out there. This particular case, or two cases, came up and was brought out. There was an article written in the New York Times about these cases. This was an interesting deep dive. It's still going on. In fact, the lawyer who represented the heirs recently died, but the case goes on. And in this case, we can see the differences between the extrajudicial abroad, meaning the advisory committees in Europe, and how they decided versus museums that have different obligations and that are defending these cases as to whether or not it was a forced sale or sale under duress. So you may hear a little bit more about these, or you may find that they stay in the museums. Two other cases of note. One is the Silver case, which was filed in December, so not that long ago. This was a case that was filed in the Northern District in Oakland, involving some nefarious claims made against the Met. And it gets very interesting because the person who was in charge at the Met was actually involved with the Monuments Men. So I encourage you to read this. This is at early stages, but keep your eye on this case. And again, just want to go through very quickly. This is the other case that was recently filed, not even a month ago, just a number of weeks ago. And this was filed in New York State Supreme Court. This involved the heirs of Carl Adler and a particular very famous Picasso. It's an extraordinary work. And the heirs are alleging that the sale was made under duress. The Guggenheim is defending, claiming it was not under duress. So what do we take from all of this? I think a number of things to weave it together. Number one, these cases aren't ending. You're going to see them. When I teach my students, I say, I wish I didn't have to talk about this anymore. But as you can hear, these cases are going to go on certainly beyond my lifetime. So you will continue to hear about them one way or another, however they're dealt with. The other thing is to keep in mind that facts are so different between cases. And so you can't necessarily generalize and say, oh, it's all this way or it's all that way. So keep in mind the stories. Number one, it keeps the heirs and the original owners' stories alive. But keep in mind, too, that there may be very many facts, as you heard from Judge Frankel, that may necessitate another type of finding. And finally, keep in mind that we can do things not only within law, we need the law to keep us honest and promote change, but also that there are many areas for creativity, not only in the deals you strike, but even on the parts of museums in terms of how museums talk about the works that are in their collections. So there's a lot of room here to do a lot of good, whether it's on the law side or the museum side or the auction side, however you decide to do it. Thank you.
Thank you very much, Professor. Now, we have about 5 minutes left. We're going to open it up to the audience for questions. And so I'll give the microphone to Kathleen, who can find the people that are asking questions.
And we will also take some questions from the virtual audience. So Alex will monitor those. Yes. Great. Yes.
I just want to ask you about the human rights context. I came back from the UK and got my PhD in children's human rights law pre-Brexit, but you're talking about like the 1995 Convention on Stolen or Illegally Exported Cultural Objects, and in that case, you know, how it plays out there. I'm not talking just about new museums. It could be state parties, it could be individuals. Potentially the International Convention on Civil and Political Rights, you know, not possessing other people's property. I even thought like maybe as an individual, right to family and your right to home and possessions and things like that. And not necessarily that you're going to get the art because of a case, but that state parties or individuals do this in order to expose it and the restitution need and everything. And I wanted to know if you could like talk a little bit about that. It's not my area, but I was like researching it while you were.
It's a great question. Does anyone else want to handle it, or do you want me to jump in? So great question. In the case I was talking about the works, the medieval works in Germany, the appeals court actually opened up a potential avenue involving international rights, because one of the things that we don't recognize, or at least that we hope not to recognize, is things done in violation of international rights, and that was part of the reasoning by the Circuit Court. Unfortunately, the Supreme Court did not follow that line of reasoning. But there is a clamor. We just haven't had, that was our one case to really hold on to, that says, you know, violation of international law in the larger picture should have some effect. So it's a great question, and I don't think it's completely closed, although certainly in the United States it's much harder now.
I have a couple of questions from people online. First one, any tips on how a practicing attorney can break into art law?
It's all happenstance for us. We were just fortunate to be approached by the Mossy family and had the privilege to represent them these last 12 years. I'm sure there are ways you could seek it out, but it came to us.
I mean, getting a background in civil litigation, if that's what you want to do, and then trying to gravitate towards potential clients who are in the field. But I do think it's a lot of happenstance. One of the more significant cases I handled in private practice was a dispute involving New Guinea tribal art at the De Young Museum. And I got a call one day from a lawyer I didn't know in New York saying, "Hi, you were recommended to me by and he thought you might be able to help." And I was like, great. And we talked about it. I ran a conflict. Anyway, about 3 months later, I was talking to him regularly because he was the client's regular counsel. And I said, by the way, I can't remember who recommended me to you. And he said, oh, it was And I didn't hear it. And at that point, I'm thinking, I can never ask again. So I don't know.
But I echo all of that, and get good experience as a lawyer. Get good experience. It's never going to hurt you in any field. And then if you're lucky enough to have either a background, I came in with the art history background, didn't go for my PhD, although I did consider it, but it really helps you enormously. You have to love the area you practice in, and it will draw you to that and to the people who practice in that area.
One more question from an online viewer. It's a bit long. If an auctioneer knew what the true provenance of a painting is and knew that it had been a work of art lost due to persecution and sold by the NSP during the war at a famous auction, but the auctioneer gave an erroneous provenance intentionally in its sale catalog, presumably to facilitate the sale, then is the claimant's best course of action in order to reach a just and fair solution to contact the authorities in the state of jurisdiction where the auctioneer conducts its business, especially if the auctioneer is unresponsive?
Is there a short version of that question? I think that's a more legal question than an art historical question. So, is the person asking has the auctioneer made a misrepresentation, or the country involved? The auctioneer.
The auctioneer, yes.
Is the questioner asking whether what we would do if we were aware of that misrepresentation, or was the questioner asking if we were the ones that made the misrepresentation? I didn't get it.
Difficult to glean from the question.
I have a thought, which is if the question is, could the auction house be legally liable? I don't know if there could be some kind of criminal responsibility, but I think the only party that could seek to recover from an auction house for that would be the party that had purchased the work at auction, if they did, and then found they didn't actually have the title they thought they did. But it sounds very much like a hypothetical.
And we'll take a couple more questions now from the in-person audience, and then we will, for those of you who are here in person, we do have a reception afterwards, and I'm sure you'll have a chance to talk with members of the distinguished panel there as well.
Hi, thank you for the interesting presentation. Judge Finkel talked about a situation where sort of the statute of limitations was invoked before this recent act, but it seemed in that case that the procedural argument aligned with what the museum perceived to be sort of a more tenuous substantive claim of the Viennese nurse, I think. But then I was thinking more of a situation where there's an extremely strong, almost undisputed claim on the merits, but then an equally strong claim on a procedural default. And there would really, I think, put in sharp relief, those competing ethical situations. And normally a litigator would say, we're going to zealously advocate every possibility we can get out of this case. But here there seems to be sort of a more equivocal stance. And I was wondering, are there some procedural defenses that might be taken off the table given sort of the competing roles or sort of alignment of the museums?
I'll say a couple words. I think most U.S. museums that were faced with a claim that they concluded was a meritorious claim would not invoke statute of limitations, most. But you still see these issues come up, and the case I'll mention, which we haven't mentioned, is the Kassir case against the...
I didn't get to that.
Oh, yes.
Oh, my goodness, and I was supposed to include that.
Yeah.
You want to take it, Simon?
I'll just say, so the Kassir case, which maybe has reached a conclusion, but it has been going on for 12 years or something,
At least, yeah.
was a case brought by a family of heirs of a Jewish family, and the painting had ended up in the Thyssen-Bornemisza Museum in Madrid, which is a state museum, and it, I think everyone agrees it was stolen at some point. But under Spanish law, the museum or its predecessors had gained what's called prescriptive rights. Under civil law, if you possess properties for a certain period, it's actually still true in Louisiana, by the way, and played a role in one Nazi-era art restitution case. But if you possess it for a certain period and with certain other factors, you gain title. So the entire case, ultimately, after years of litigation, all the way up to the Supreme Court, was that it was brought in the Central District of Los Angeles, but the Supreme Court said the choice of law of the forum applies, and which the court had not done. So they sent it back for that, and the district court applied the choice of law of California and decided under California's comparative impairment, Spanish law should apply, and found for the museum, and that was just affirmed a couple months ago by the Ninth Circuit.
Yeah,
very recently by the
recently.
Ninth
This
Circuit.
year was published.
Yeah, you're right, it was January.
Yeah, it was I think it was January 9.
And so that's a case where the museum, again, it's a European museum, it's state-owned, it's a little different, but that museum was willing to say it may have been stolen, but we own it under Spanish law, and we're sticking with it.
And a side point was one of the dissenting judges, well, no, actually the judge who concurred, but mentioned morally the difficulty because Spain had signed both the Washington Principles and the Dresden Declaration as well.
And I'll just say you see this in a few judicial opinions where they reach a result that they aren't happy about morally, and so they sort of say, really, you legal actors, you ought to do something different, but we know we can't force you to.
Fascinating presentation. I think my question's directed maybe to to art houses or auctioneers. One, have there been relatively recent advances in technology that help in this effort? For example, Google wants to digitize the entire world. And second, what does the art world, are they ready for the next Hitler? Like, have we learned anything from this? And have we adjusted, like, do we have contingency plans in place? And, Russia invades Ukraine, for example. So.
Those are very good questions. I mentioned in my brief talk that one of the things that led to the Washington Conference and its principles, from my perspective, was the opening up of archives, but equally importantly, the digitization possibilities for those archives with the advent of the internet. And since then, so 25 years later now, the sheer wealth of data available to people like us in restitution, provenance researchers, is incredible. But people in the world of technology, which I'm very much not, are always amazed that our researchers check each and every lot against not just one database. There's not just one box that you type in Monet and every single result comes up from every database. They do it against 7 or 8 different databases. They're not streamed together. It's not just a sort of I'm sure the technological solution would be there, but this data is proprietary. It's owned by different organizations like the Art Loss Register, which is a paid-for service. They're not going to give us their data. We pay them to access it themselves and do their checking part. The German governmental database, lostart.de, is owned by the German government. So these things can't all be streamed together. So it's a much more complicated, arduous pre-sale checking procedure than you might imagine. That's one thing. So I would say there are 8 or 9 databases we now check. When I began in 2006 in this field, there were 2. So that's expanded beyond all imagination. Your other question was about whether the art trade has learned from our experience looking into unresolved Nazi-era looting and duress sale cases over the last 25 years. I think that I hope we're more vigilant than ever. My focus as a leader in this field in the auction houses is only 1933-45 losses, but we have, of course, legal teams and compliance teams that deal with a whole wealth of different loss scenarios. Ukraine being one recent example, and embargo on dealing with Russian art owners or art buyers or consigners. Those sorts of things are very much live issues. We're more and more vigilant about artifacts looted by the British and others from Nigeria, for instance, Benin bronzes. We won't now offer them for sale at auction. So these issues are vast and ongoing. Many of them are dealt with by the legal and compliance teams at Christie's and indeed at Sotheby's. But yeah.
Add one point. Just another angle of your question, I think, was what have we learned sort of in terms of proactivity in times of war? And I worry a little that the prescience of the Monuments Men, I mean, it's astonishing to me that the U.S. government was thinking like a year before Normandy, we need people there with this expertise. Now, as Richard said, it was focused initially more on the cultural monuments, churches and such, but it turned into a much broader, but they were thinking about that. It's so amazing to me. When we went into Iraq in 2003, I don't know, but I haven't heard anything that makes me think the U.S. was thinking we have to safeguard their museums, and the result was there was a lot of looting at the museums, I know in Baghdad, and it's...
There is a new version of the monuments.
Yes, in Italy, am I correct?
And in the US.
Well,
yeah.
definitely in the US.
Yeah.
In the case of Ukraine, I believe that there's essentially a European version of the Monuments Men that has now been working with some of those in the US as well.
We have had the privilege of hearing from 4 of the most knowledgeable people in the world in this area. Let's give a big round of applause for them. Thank you for attending. Reception's outside.
Thank you. Fascinating.
Thank you, Richard.
Oh, my pleasure. I love this area.